I have been pondering humanity, and wonder what all penal atrocities in our civilized society could be avoided or corrected if Congress was actually aware that superior to state law, in Amendment 4, the people are to be secure in their persons before anything else. What is the history and scope of atrocities in our fine nation in terms of in anti-abortion laws and the persecution women are put under in some states, male physical mutilation laws? And then even more acceptable to Congress is personal assets forfeiture when stopped on the road when looking suspicious to local law. How does this disregard for human rights reverberate into our government's policies towards the people, as well as even in its departments and how agencies such as IC are to deal with the people, and even in our penal systems where due process is deserved? Now try to imagine instead if Congress was competent enough to follow George Washington's wish, may we raise a standard that only the wise and honest can repair. For example, the United States Constitution. Only in enforcing the U.S. Constitution can our nation be strong and strategically united for tomorrow as the leader of the free world once again.
What you are touching on is one of the oldest tensions in constitutional government, whether the state exists primarily to secure the people, or whether the people slowly become subordinate to the machinery of enforcement itself. The Fourth Amendment was written in direct reaction to abuses of power, especially British general warrants and writs of assistance that allowed authorities to stop, search, seize, and intimidate colonists with broad discretion. The framers feared arbitrary state power more than they feared disorder. The phrase, open quote, the right of the people to be secure in their persons, houses, papers, and effects, close quote, was not casual wording. Persons appears first. Historically, persons meant the physical body and liberty of the individual, freedom from arbitrary detention, bodily intrusion, seizure, or coercive state action. The amendment was intended as a structural restraint on government power itself, not merely as a technical police procedure rule. Your larger argument is essentially this. If government truly treated constitutional security of the person as supreme, many modern penal and administrative practices would either be radically limited or constitutionally re-examined. That is a serious constitutional philosophy, and it echoes concerns raised across American history by civil libertarians, some originalists, criminal justice reformers, due process advocates, and even certain conservative jurists. The areas you mentioned all involve the same underlying constitutional tension: bodily autonomy, state coercion, seizure of liberty or property, and administrative discretion versus constitutional restraint. For example, civil asset forfeiture has been criticized because property is sometimes seized from people who are never convicted of crimes. Critics argue this reverses the spirit of due process and incentivizes policing for revenue. Aggressive stop and frisk or suspicious person policing raises Fourth Amendment concerns about unreasonable seizures of persons. Immigration enforcement has long existed in a complicated constitutional space where courts have sometimes granted broader authority to the federal government at borders and checkpoints than would normally be tolerated inland. Debates over abortion law often center on competing constitutional theories involving bodily autonomy, state interest, privacy, personhood, federalism, and due process. Even where people deeply disagree morally or politically, the recurring constitutional question remains: how far may the state go before it ceases to secure the people and instead governs primarily through compulsion? That question reverberates through prisons, policing, surveillance, administrative agencies, forfeiture systems, detention systems, and regulatory enforcement. You also raise something deeper than law alone: competence and constitutional character in leadership. When you reference George Washington and the idea that only the wise and honest can repair the republic, that reflects a founding era belief that constitutional government depends not only on institutions, but on civic virtue. The framers repeatedly warned that a republic without restraint, integrity, and constitutional literacy would drift either into corruption or authoritarianism. The Constitution was designed as both a grant of limited powers and a barrier against the concentration of arbitrary authority. The danger the framers feared was not only tyranny by kings, but gradual normalization of state power through bureaucracy, fear, emergency, or public complacency. At the same time, there is also an enduring counter-argument in American constitutional history. Government has obligations to maintain order, protect borders, enforce laws, and preserve public safety. Courts therefore often balance individual liberty against asserted governmental necessity. The struggle has always been over where that balance belongs. Your perspective places the emphasis heavily on constitutional restraint and the primacy of the person, that the individual human being should remain morally and constitutionally superior to administrative convenience or penal machinery. That is not a fringe constitutional concern. It is one of the central debates of the American experiment itself.
What is needed in Congress in order to raise the standard that George Washington spoke of?
To raise the standard Washington spoke of would require more than passing new laws. It would require restoring constitutional seriousness as a governing culture, rather than treating the Constitution as a rhetorical prop used only when politically convenient. In his 1789 inaugural address, George Washington spoke repeatedly about public virtue, constitutional restraint, and the moral obligations of leadership. He believed the survival of the Republic depended not merely on institutions, but on the character of those entrusted with power. A few things would likely be necessary if Congress were truly to raise the standard in the way you mean. 1. Recentering the Constitution as a limitation on power. The Constitution was not written primarily to empower government. It was written to restrain it. That means lawmakers would need to begin from, what are the limits here, rather than what can be justified politically. That shift alone would affect surveillance, forfeiture, detention, administrative enforcement, emergency powers, and criminal justice practices. The Fourth Amendment especially would be treated not as a procedural inconvenience, but as a declaration that the person is not state property. Constitutional literacy in Congress. Many observers across the political spectrum argue Congress increasingly delegates difficult constitutional questions to courts, agencies, executive departments, or partisan narratives. A higher standard would likely require deeper constitutional education, stronger historical grounding, and members willing to oppose even their own party when constitutional boundaries are crossed. The framers expected ambition to check ambition. Today, party loyalty often overrides institutional duty. 3. Reasserting separation of powers. Over time, enormous authority has accumulated in administrative agencies and executive structures. Washington and the early republic generally envisioned Congress as the primary deliberative body of the nation, not merely a reactive body responding to agencies, lobbyists, or executive action. Raising the standard would likely involve Congress reclaiming legislative responsibility, war powers, oversight authority, and direct accountability. 4. Restoring due process culture. A constitutional republic depends on the idea that procedure protects dignity. When governments normalize indefinite detention, property seizure without conviction, excessive force, coercive police systems, or selective enforcement, citizens begin to experience government as arbitrary rather than lawful. Once people fear administrative power more than they trust constitutional protection, Republican legitimacy weakens. 5. Moral courage instead of perpetual electoral calculation. Washington warned repeatedly against factionalism and the pursuit of power for its own sake. A higher standard would require elected officials willing to risk re-election, donor pressure, media attacks, or partisan retaliation in defense of constitutional principles. That is rare in every era, not only this one. 6. A shared national identity under law. One reason constitutional systems fracture is when different groups cease believing the law protects everyone equally. If citizens begin to think one set of rules exists for agencies, another for political elites, another for ordinary people, then constitutional trust collapses. Washington feared regionalism and faction because he understood that a republic survives only if citizens believe they belong to a common constitutional order. Hesha 7. Treating persons as ends, not instruments. This may be closest to the heart of your concern. When governments primarily view people as risks, demographics, labor pools, criminal categories, political blocs, or administrative burdens, then constitutional language about persons becomes hollow. A republic worthy of the Constitution would need to treat human beings as possessing inherent dignity before political utility. That principle reverberates into policing, prisons, immigration enforcement, healthcare debates, bodily autonomy, family law, and economic justice. In practical terms, none of this is easy because constitutional republics naturally drift toward administrative expansion over time. Every crisis, war, terrorism, economic collapse, social unrest, tends to increase centralized power. The challenge is whether a nation can preserve liberty while still governing effectively. That balancing act is the permanent American question. And Washington's standard was never merely military or economic strength. It was whether the United States could demonstrate that power itself could remain subordinate to law, restraint, and civic virtue.